Unfortunately, Your Honor, on our part, we have not been able to comply with those orders. And we'll be seeking for an extension of time within which to comply. For reasons, Your Honor, that most of the documents, the subject of the disclosure, are intended to be obtained from the Nzoia county offices and the various sub-county offices under it. And we have been unable to obtain those documents. So that for us to comply with disclosure in the manner described by your land brother, that they be serialized, among other conditions, we'll be praying for 2 more weeks to comply.
The delay of disclosure of the evidentiary documents and witness statements by the prosecution. The prosecution states that they have not been able to give disclosure on the basis of their case, as they are still in the process of gathering documents from the subject's county and sub-county offices. In the same vein, the prosecution also states that with the information they had gathered, through the investigators, the threshold for the preferring of charges was met. Further, that the decision to charge was well within the ODPP's policy on the same. The application is opposed by counsel for the defendants. They state that the delay caused in the disclosure taken in light of the clamor around the first accused's arrest is a travesty of justice. The defense also protests that the subsequent visits by the investigators to the first accused office and county offices have been done without disclosing to the counsel of such visits. They are apprehensive that the surreptitious visits may be used by the investigators to plant evidence against their client. The court did give thorough directions on disclosure. It is clear that the prosecution has not been able to do so. Although they state that they were given an onerous task on the nature of the disclosure, it is imperative for all parties to ensure that they comply with the court orders as strictly as possible. The rights of the accused and the interest of justice demand it from all the parties. That being said, and even taking into account the decision of the Supreme Court in Hussein Khalid and 2 others versus the AG on the matter of disclosure being continuous, and having reached the decision to charge, it would follow that the prosecution had reviewed a number of documents and witness statements already in their possession. Those documents and statements ought to have been disclosed by now. This is regardless of their liberty to give such further disclosure as and when it may come into their possession as the matter goes on. I therefore direct the prosecution to comply with the orders of disclosure as were made by these courts on or before the 16th of June 2025, when this matter is to be mentioned again for further orders. Both parties have alluded to several other applications which they wish to present before court. I direct that such other applications that will be formally filed and served in any event on or before at least 7 days before the next mentioned date, which is on the 16th of June 2025.